Hey, good morning. I'm the judge today, Ken Gottlieb, presiding over First Appearance Court. Today's the day that you'll hear of your charges and will determine whether there's probable cause, and then we'll determine the bond, or if you're released. Everything has been recorded, so please remember that you do have a right to remain silent. Whatever you say about your arrest or the facts surrounding your arrest will be used against you because this hearing is being recorded. You are entitled to an attorney. If you can't afford one, the public defender can help you today. So let's move on to the first case, Tatiana Saravia.
She's approaching, Judge. She's here at Maine. Come on up now.
She has three cases with capiases, or three capiases for $500 each.
Correct, Judge. It's the same case number. I did talk to Ms. Saravia a little bit before we started here today, and she has advised me that she wishes to resolve these matters, so I wanted to see if the state had a plea offer for her.
So withhold court costs, Judge, all three counts.
Okay. Would you like to resolve the case for a withhold of adjudication and court costs?
She would, Judge.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Do you understand English?
Yes.
How far did you go in school?
12th grade?
Do you understand the charge?
Yes.
Do you wish to enter a plea of no contest?
Yes.
Okay. And do you have any questions for your attorney?
No.
Do you understand this plea could serve as a basis for your license being suspended, revoked, or you being declared a habitual traffic offender?
Yes.
And do you understand if you're not a citizen of the United States, regardless whether you're here legally or not, this plea will subject you to deportation?
Yes.
I find you've made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea, and based on the documents in the file, I find a factual basis for the plea. I'll sentence you to a withhold court costs on all counts. Good luck to you. Michelle Brooks.
Ms. Brooks is approaching, Judge. Come on up, ma'am.
Okay. Ms. Brooks has a capias of 250 on case 19002744 MM40A and on case 19003201 MO40A, a $100 bond. And she has a status set for tomorrow morning in Division MA. Okay?
Judge, speaking of Ms. Brooks, I see that she has a state offense and also a city ordinance offense. But in speaking of Ms. Brooks, she wishes to resolve this matter, so we wanted to see if the state had a plea offer for her.
Okay, and I believe Mr. Plant is here.
Yes, thank you,
with her.
Judge. Good afternoon. Good afternoon, Mr. Romero.
Good afternoon, Mr. Plant.
Our offer hinges on the state. Our offer is adjudicate time served. City of Hollywood.
Okay, I'm just gonna roll it over till tomorrow, and she could take it up
See you there.
in Division MA.
You can resolve it tomorrow, ma'am.
Judge, would the state attorney be able to make a relay an offer for today so she doesn't have to stay an additional night in jail?
State, do you have an offer?
Not at this time, Judge.
They do not have an offer at this time, is what they're saying.
I understand.
So I'm gonna keep the bond the way it is and find probable cause. Thank you very much. We'll move on to Brianna Cache.
I
Brianna,
believe she bonded, Judge.
okay. I do find probable cause as well, for the record. Shebra Jana Stevens.
She's here at Maine, Judge.
Okay, she's capiast on case 200000736 MO10A and has a status set up tomorrow morning in Division MA. Ms. Stevens' lawyer is here, Mr. Plant.
Judge, we can see you tomorrow in court.
I didn't hear you. What do you say?
We're going to see you tomorrow in court, ma'am.
The case is, I find probable cause. You have a capias for your hearing, which is set for tomorrow morning at 9 a.m. So you'll see your judge in the morning in your division. You may be able to resolve it there, or you may be able to get your hearing date for your day in court. Okay?
Okay.
Good luck to you.
Thank you.
Okay, Zandria Malise Dials.
Bonded, Judge.
Okay. For the record, I did find probable cause. Okay, Heather Ann Amari.
Judge, she's at North Broward. She is also on the second look docket.
So would you like me to wait and do it at the second look?
I'm happy to do both of them now if it please the court.
Okay, let's go to North Broward. Is it the same case? Let's see.
I cannot tell you, Judge. I'll have to look that up. There we go. So, Judge, I spoke with Ms. Amari. She's unable to afford the bond. No one to bond her out. It's $1,000 for a possession charge. I believe she also has another possession charge pending. She is a 5-year resident of South Florida. She's lived at the same address for all those 5 years. She works as an insurance salesperson. And if the court would allow her to be released to pretrial services, she would not object to a condition that she seek treatment with bark. So,
Okay, State, do you have any objection to that?
Yes, Judge, the state would be objecting. The basis is that Ms. Amari had an arrest for a drug paraphernalia on January 27th, and then picked up this case 2 weeks afterwards. And there is currently a pending case in front of Your Honor as well, and she has other pending MO cases as well. So the state would be objecting to.
Does she have a history of not showing up to court?
No. No, I don't.
Does she have a place to live as well?
Yes.
Your Honor, my client is advising me she does.
Okay.
That's
Okay, then I will ROR her. I'll put her into pretrial. She'll get, for pretrial, which monitor do you use?
There we go.
On level 2 with an open schedule, or it can be standard supervision pending verification of an address.
Yeah, we'll need the standard, we'll need the address, but I want to put a monitor on her.
That's even better, so that would be level 2. That would be level 2.
That
Judge,
will-
may I?
And I want it to be the monitor that will test her.
And random testing?
The state would ask for that.
No, doesn't like the scram. Do you do the scram or the
The
TAD?
TAD monitor only tests for alcohol. It doesn't test for narcotics.
Okay,
So you're gonna need to do random drug testing. The court wants to order an evaluation, the court could also order.
I want her in bark, any follow-up treatment, and a monitor.
So, Judge, there are 3 levels of supervision. Level 1 is house arrest. She can't do anything except go to the hospital and
I don't-
to see her attorney.
She can.
Level 2, she's allowed to work, go to school, et cetera, et cetera. And then you can put her on with an open schedule, which allows her to walk about freely. However, they can keep tabs on her with the GPS.
Okay, and I think it was recommended for a 2, and I'm agreeable to that.
For the record, Judge, she did have a KPS issued on March 13th, 2019.
For like the last 2 days, it's the same case number that's on for the second. So it's technically only one case. We finally got her into court.
Okay. Thank you very much, and good luck to you.
Judge, with the court permission, I'd like to consult with my client very briefly. So if North Broward, you could hold her for 1 moment.
Okay, North Broward, please hold her for a minute so her lawyer could talk to her. Thank you. And we'll move on to Stephen Resnick.
Conti, Your Honor.
Okay. Mr. Resnick, you have an out-of-state hold on a felony. I am going, and with a no bond hold, and I find probable cause. So, Mr. Miller, was there anything you wanted to say on that? Mr. Miller? Counsel? He's involved. Just 1 second. Do you have anything to add to Mr. Resnick? He has an out-of-state hold, no bond hold.
No, Your Honor. My office will be in touch with him briefly or shortly regarding the extradition.
Okay, I will ask Conti to hold Mr. Resnick so his lawyer could speak to him on the phone for a minute. Thank you.
Yes, sir.
Thank you very much. Travis Joseph Page.
Mr. Page is here. Main judge approaching. Mr. Page, come on up. And Judge, just for the court's edification, on page 11, there's a gentleman here named Mr. Joan Cuza. He's going to require a Spanish interpreter. So I don't know, Mr. Miller will contact the interpreter's office to get an interpreter.
Okay, thank you.
How you doing, Jan?
Can you call for an interpreter? Okay, good morning. You have been charged, actually, you have a case, a city case and a capias for $500 on, or $100 on that case. It was a trespass. Before you say anything, Mr. Plant is here on your behalf.
Judge, will the court accept a adjudicate time served for him?
I'm sorry, what?
His offers adjudication time served.
And the city offered that to him?
City of Hollywood.
Do you wish to resolve this case at that time? The
It's time,
trespass?
sir?
Yes.
I couldn't hear. Yes, sir.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Correct.
You can put your hand down. Do you understand English?
Yeah.
How far did you go in school?
9th grade?
Do you understand the charges?
Yes, sir.
Do you have any questions for your attorney?
No.
Do you wish to enter a plea of no contest?
Yes, sir.
Are you under the influence of drugs, alcohol, any other substance, or do you suffer from any mental illness?
No, sir.
Has anyone threatened you, coerced you, or promised you anything to get you to make this plea?
No, sir.
And do you understand, if you are not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
Correct.
I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea, and based on the documents in the file, I find a factual basis for the plea, and I'll sentence you to an adjudication court cost credit for time served. Good luck to you, sir.
Yes, sir.
Donald Cooper.
Mr. Cooper, Paul Ryan Facility Judge.
Okay, Mr. Cooper, you have been charged with a petty theft, second degree, first offense. Your bond was set at $25. You have an arraignment on a felony case on 2/17 at 9 a.m. Counsel?
Judge, proof evident presumption rate was found on count 1 back in January. We just asked the court to keep the bond as set and pass this through.
Okay, so this was just an add-on of the petty theft. I'll just keep everything the same. I did find probable cause, and I will keep the bond at $25. Good luck to you, sir. Henry Cordero.
In jail.
Come on up, Mr. Cordero.
Okay, sir, you've been charged with operating without a valid license. The recommended bond was $25, and you have a writ of arrest for $923. I do find probable cause. Did you have anything to add, counsel?
Judge, I'm just going to be requesting a phone order.
Okay. I will grant that order if Mr. Miller writes it up, and we'll keep the bond as it is after finding probable cause.
Thank you, Judge.
Thank you. Good luck to you, sir. Andre Walker.
He's approaching, Judge, here at me.
Okay, sir. You have been charged with a false ID given to law enforcement and resisting officer without violence. I do find probable cause. Counsel?
Judge, in speaking Mr. Walker, he wishes to resolve this matter today. We wanted to see if the state had a plea offer.
State, do you have an offer?
Not at this time, Judge.
Okay. They do not have an offer. I will keep the bond at $100. On the
Judge,
resisting,
certainly,
there
sorry.
was none. So I could keep it all at $100.
Judge, at this time, I would like to invite the court into plea negotiations. Certainly, it is within the court's purview to resolve this matter. These are both misdemeanor offenses. They're nonviolent by nature. So, Judge, I'm going to be asking if the court would consider extending an offer of adjudication time served.
Actually, after reviewing the probable cause affidavit, I was not inclined to do that. So I'll let you represent him in front of the judge that this case is going to. And it is a low bond of only $100. So thank you very much.
Judge, Mr. Walker, I did advise him that the court and the state has no plea offer at this time, that he's going to have to go before his division judge if this case even gets filed. Having said that, Judge, from what I advise him right now, his bond is $100. He advised me he can't afford that. Would the court consider an ROR on Mr. Walker's behalf?
Any objection to that?
Yes, Judge. Based on the allegations on the report.
Okay.
But he has no priors in Broward. He has no priors in Broward or in Florida.
He has no priors whatsoever?
No, Judge.
I will ROR him at this time.
Thank you, Judge. And I'll give him instructions what to do to keep in touch with so he doesn't miss any future court dates.
Yes. Jeffrey Deshawn Delva.
Mr. Delva, come on up. Mr. Walker, here's your instructions. Keep this. Do not miss any court dates. The phone number.
And wait.
And the website. Yes?
Okay, I just want to add as well, it's an ROR, but no victim contact, direct or indirect.
Mr. Walker, no victim contact. You understand? Thank you.
Okay. Jeffrey Delva.
He's here, Judge.
He has an outstanding capias for $250. Counsel?
And Judge Delva wishes to resolve this matter today. We wanted to know if the state had a plea offer.
State?
It's
It's
a
for-
withhold court cause, Judge.
It's for driving with his license suspended. I want to advise you, sir, that once you receive 3 driving with your license suspended within a 5-year period, your license will be habitualized. And there's a new law now that if you get your 3rd period after October 1st, 2019, which has passed, your 3rd one will come with a minimum mandatory of 10 days jail. Do you understand?
Yes, sir.
Okay. And you'd like to resolve this case?
Yes, sir.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Do you understand English?
Yes, sir.
How far did you go in school?
10th grade.
Do you understand the charges?
Yes, sir.
Do you wish to enter a plea of no contest?
Yes, sir.
Do you have any questions for your attorney?
Sir.
Do you have any questions for me?
No.
Do you understand the minimum and maximum penalties?
Yes.
Are you under the influence of drugs, alcohol, any other substance, or do you suffer from any mental illness?
No, not at all.
Has anyone threatened you, coerced you, or promised you anything to get you to make the plea?
No.
And do you understand this plea could serve as a basis for your license being suspended, revoked, or you being declared a habitual traffic offender?
Yes, sir.
And do you understand if you're not a citizen of the United States, regardless whether you're here legally or not, this plea will subject you to deportation?
Yes, sir.
I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea. And based on the documents in the file, I find a factual basis for the plea. I'll sentence you to a withhold court costs. Good luck to you, sir. Aaron Jeremiah Anglin.
Mr. Anglin, come on up, please. He's approaching Judge Sharp, man.
Okay, sir, you've been charged with robbery by sudden snatching without a firearm or weapon. I find probable cause. Counsel,
Judge, I'm sorry.
go ahead.
Judge, in speaking with Mr. England, my understanding is this is his first contact with the criminal justice system. He has a clean record. He's 19 years old, been here his whole entire life. He attended Boyd Anderson High School. He lives here in Fort Lauderdale with his mother, a single mother, where she rents. She does not own here in Fort Lauderdale, where they've been residing for the past 4 years. My understanding, the only person that can help post his monetary bond is his mother. She's a preschool teacher. Now, my understanding is, I believe Mr. England was not at his house. Law enforcement went to his house, gave him a card. His mother contacted him, and hence Mr. England surrendered himself here at the main jail. So obviously, Judge, he is not a flight risk. Based on him not being a flight risk, 2, his lack of priors, 3, his lack of any financial resources, I'm going to be asking the court to consider setting a $1,500 bond on this offense, Judge. I believe it's a third-degree felony.
State?
Judge, our search indicates that he has a pending battery as well as a petty theft, and he's charged now with a robbery
Judge, I
by
can't hear.
snatching
They're arguing that he has a pending battery
and a pending petty theft.
and a petty theft.
And now he has a robbery by sudden snatching. The state's concerned that the level of the offenses are escalating. The state is requesting a $5,000 bond, as well as no return to the place of incident, and as well as a no victim contact order.
Judge, I just asked him and inquired if he had anything open, if he'd gone to court, if he'd been served with paperwork or anything like that. He's just as confused as I am as far as indicating I don't know what the state is referring to.
And Judge, I would add that I'm looking at the battery and a petty theft charge. That is in front of Judge Pohl. He has a summons, but it has not yet been set for hearing that I can see. I'm sorry. You have a summons to be there February 21st in front of Judge Pohl. But I would also advise the court that the alleged date of incident of this case is December. The case before the court today is April of 2019.
Okay, based on the totality of circumstances, I do not find him to be a flight risk. However, based on the nature of this charge as well as the conversation, I will set bond at $3,000. No victim contact, direct or indirect. You cannot go within 500 feet of the victim. No guns, ammunitions, or weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. And that would be it. Okay?
Yes,
Thank
yes,
you.
Your Honor.
Good
Thank
luck
you.
to you.
Since your mom posts your bond, you're gonna have to have another.
Joshua
court date.
McBride.
Listen, yeah, or else there'll be a warrant issued for your arrest, so you better go and find out about that.
We
Joshua,
have a Spanish interpreter present, Judge.
okay, once I finish this one, I'll come to the next case, okay? Joshua McBride,
He's here, President.
you've been charged with burglary, unoccupied conveyance, unarmed, 3 counts of selling cannabis, 1 count of possession with intent to sell, manufacture, or deliver, THC, and 1 count of resisting an officer without violence. The selling cannabis counts all had a recommended bond of $1,000 each. The possession with intent to sell had a recommendation of $1,000, and the resisting without violence was $100. The burglary, unoccupied conveyance, we can argue about. I do find probable cause.
Judge, I believe Mr. McBride has a clean adult record. He's 19 years old. He's looking for employment. He's been in South Florida his whole entire life. He lives with his mom. His mom's going to be the person that posts monetary bond. She works at the Dollar Tree. So on count 1 alone, I would ask the standard bonds be in place from count 2 to 6. But on 1, I'm on third-degree felony. I'm requesting a $1,000 bond.
State?
Judge, he does have prior juvenile, offenses, including a burglary, battery, and indecent exposure. The state would be asking for a $5,000 bond on count one and leaving the rest of the counts as is.
Okay? Based on the nature of the charge and everything I've heard, I'm gonna set bond on count one at $5,000, count two at 1,000, count three, 1,000, count four, 1,000, count five, 1,000, and count six, 100. Thank you, good luck to you. Daniel Berry,
Mr. Barry, come on up. Oh, he's approaching, Judge. He
Okay.
declined the service of public defender. He's gonna hire his own, but he believes his bond may have been posted.
okay, you were charged with possession of cocaine, I do find probable cause. Bond was set at $1,000, and unless there's a reason why I shouldn't, I'm gonna keep a bond I'll keep the bond there. State, did you have an argument to raise it?
Yes, Judge, it does have prior cocaine possessions. The state is requesting to increase the bond to 2,500.
Okay, I'm gonna keep the bond at 1,000, based on the priors, and good luck to you.
Thank you.
Thank you. Jeffrey Wade. Oh, wait, before I call up Mr. Wade, what case are you here on, sir?
Judge, it's page 11, Juan Israel Cuza Nunez.
Senor Cusa, Nunez.
Okay. And do you swear to translate from English to Spanish and Spanish to English?
I do, Your Honor. Zachary Shapiro, Shapiro, Spanish interpreter.
Okay, thank you.
He's approaching, Judge.
Okay. Okay, sir, you have been charged with count of grand theft,
Señora, usted la acusaron de hurto de mayor cuantía.
1, 2, 3 counts of touch or strike battery,
Tres cargos de agresión por haber golpeado o tocado.
and 3 counts of committing theft, resisting recovery of property.
Y tres cargos de cometer un robo y resistir los intentos de recuperar la propiedad.
I read the probable cause affidavit,
Yo ya leí la denuncia
and I find probable cause.
y determino que sí hay motivo fundado.
Counsel, did you have any argument with regard to bond?
Licenciado, ¿tiene algún argumento con respecto a la fianza?
Judge, based on the totality, I'm not requesting anything.
Pues con base en todo el expediente del caso no voy a solicitar fianza.
State?
Yes, Judge, he does
Fiscalía.
have priors. He has a 2013 tampering from Dade County.
Sí, pues tiene antecedentes, un del 2013, el condado de Dade por haber alterado a un testigo.
2016 grand theft,
Y otro cargo de hurto de mayor cuantía en el 2016.
2019 trespass,
Un
and
cargo
possession of
de
cocaine.
translimitación en 2019 y también
Possession of cocaine,
posesión de cocaína.
resisting without violence,
Otro cargo de resistir sin violencia,
petty theft.
hurto de menor cuantía.
He has a 2020 open case in Dade County of a grand theft.
Tiene un caso pendiente en Dade del año 2020, también es de hurto de mayor cuantía.
The charges in front of the court today are similar in nature. The state is requesting a $5,000
Y los cargos ante el juez el día de hoy son de índole similar y por eso la fiscalía va a solicitar una fianza de $5,000 con respecto al cargo número 1
and a $2,500 bond for counts 2 through 7.
y fianza de $2,500 para los cargos 2 a 7.
And Judge, well, that's why I didn't request anything. I do realize that Mr. Cusa has a history, but Mr. Cusa did advise me that he's not working. So
Pues yo entiendo
therefore,
que tiene antecedentes, pero el señor Cusa me avisó a mí que que no tiene trabajo ahora.
so that's why I wasn't gonna ask anything of the court as far as a bond reduction or anything like that.
Por
Okay,
eso no iba a pedir que el tribunal le rebajara la fianza.
count 1 through 7, I'm gonna do a $2,000 bond
Yo
for
voy a-
each count.
Poner fianzas de $2,000 para cada cargo del 1 al 7.
Thank you very much.
Muchas gracias.
Based on the priors and being a
Es con
danger
base
to the community.
En sus antecedentes y porque es un peligro para la comunidad.
Okay.
Bueno.
Thank you very much. And now we're here on Jeffrey Martin Wade.
Your Honor, yes, I have him.
Okay, this does not look like a city case.
No, well, I'm standing in
Martin
for,
Wade, North Broward.
it's not my, Steve Plant, I'm standing in for attorney record. Judge, so, we want to keep the bonds bond and all the bond conditions as is.
That's correct, Judge.
And
The
what
state
would,
knows.
It's $7,500 on every single count.
Oh, so waive formal reading as well, in case. It's actually a change of charge. He's already been through.
okay. Well, I reviewed the probable cause affidavit, and I do find probable cause. Where is he?
He's refused, Your Honor.
Okay, he's on counts 1 through 10, and I'm going to keep the bond $7,500 on each count.
Thank you, Judge. Yeah, all conditions
Same
apply.
conditions as before. Well, you came on each one, that was a city case, so I just thought I'd point that out. Okay, thank you. Moving on to Joel Gonzalez.
Judge, he's at the
Joel
main
Gonzalez,
jail.
I believe bonded.
Yeah, there we go.
I do find probable cause, though. Terry Jackson.
He's here present, Judge at main.
Okay,
Judge, Mr. Jackson is set for arraignment on February 17th. Proof evidence presumption great was found on January 23rd for these charges. The bond, he's being held no bond. I'd ask the court to pass this through.
okay,
Is it still the PVL?
I will, and I do find, when I reviewed this, that I did find the proof of guilt to be evident or the presumption great. And
Judge, just for the record, I'd ask the court to find that without prejudice so that he can have a full-blown Arthur hearing in front of his division judge.
I will grant that.
Thank you.
Thank you. Gary Leon White.
Judge, Mr. White is at North Broward. However, he declined the court's invitation to appear this afternoon. He does have a St. Lucie County no bond hold and a $25 bond. I'd ask the court to pass this through.
Okay, I will. I do find probable cause. Count 1 is $25, and count 3 is a no bond hold because of an out-of-county hold on a felony. Okay, and that was the last one of that, so we'll move on to the next docket. Okay, and so that would bring us to Brandon Goss. Brandon Goss?
Mr. Goss is at North Broward, Judge?
This is a second,
Yes, Judge. He's been in custody for 4 days on possession of methamphetamines, resisting, it looks like without violence.
correct.
He
And
cannot afford
Judge-
the bond as
Judge-
currently set. I spoke to him earlier. He is a 2-year resident of South Florida, living at the same address for the entire time. He is currently unemployed, but he has worked in the past, doing HVAC, solar panel installation, that sort of thing. He does have a place to stay once he is released. Judge, if the court would consider lowering the bond to $1,000 total, he believes he can find someone to post that bond.
Okay, Judge Cawthon found probable cause, and she
She raised.
raised the bond from 1,000 to 2,500. State, did he have any priors?
Yes, Your Honor. He has the same charge that, on a different case, 6 days prior to picking up this case. So that's the reason why Judge Coffin raised the bond to 2,500. The state asked that you maintain the bond as is, and the state is objecting to the ROR motion.
Does he have any priors, though? Other than that one?
Yes, Judge. He has, that prior, the same charge. He has a resisting without violence from 2018. He has an unlawful use of a name, possession of drug paraphernalia and a trespass from 2018. He has another possession of methamphetamine, unlawful use of false name, possession of drug paraphernalia and a trespass from 2017.
It's the same thing.
DWLS from 2014, and those are his priors in Broward, Judge.
Okay, I'm gonna find that He has numerous priors similar. I'm gonna keep the bond at $2,500. Thank you. Sean Faulkner,
He is at Main Jail, Your Honor.
Come on, Sean.
Looks like he was arrested February 10th, and has been in custody on this $25 bond for an open container charge since.
Let the judge know.
okay,
What's wrong? Let the judge know.
you've been charged with a open container. It's a municipal ordinance. If you'd like to resolve it, I'll resolve your case today for an
I
adjudication.
wanna, fight it. I wanna fight it because it's, officer, after I feel like he's arrested me, so I wanna plead not guilty to it.
Okay, you could do that at the arraignment, and just keep it, the minimum bond at $25, so you can do that shortly.
I know.
And I'll appoint Steve
I
Shea.
don't need a lawyer because I can get time served, you know, I don't want you to waste that time.
Okay, good luck to you, sir.
So is that cool?
Yeah.
Thank you.
Thank you, Anthony Brown.
He's at the Main, Your Honor.
Did he bond?
No.
He's
here
approaching.
present, Judge.
Okay,
I understand.
it said he bonded.
No, he didn't bond. He's still here. That's what happened the first time.
Okay.
And he wasn't brought. Come on up. And unfortunately, I believe when they looked him up, it's a different Anthony Brown. He advised me, he can't afford the bond. It's $1,500. Judge, he lives here locally in an apartment that he's been living at for 2 years with a roommate. He works for a company called Fort Lauderdale RV. He's a groundskeeper there, but no one's gonna be able to afford to post his bond. We're asking for him to be released on pretrial release.
Okay. State, any objection?
Judge, the state is fine with that. The state would also add random testing at defendant's cost and no alcohol, no intoxicants, based on his drug priors from Illinois.
Okay, I will reduce his bond to an ROR. I will require him be on pretrial, no alcohol, no intoxicants, and random drug testing.
So this is pretrial. You must report there. They're gonna be closed by the time you get there tonight. So you have to show up tomorrow morning. If you don't show up, the warrant will be issued for your arrest. Do you understand? Okay. Thank you, Judge.
Thank you. Good luck. Then we have Donald Cooper. Okay, I thought Cooper was something from this morning that had to be heard again.
Was reset from this morning, but Your Honor, we requested that you pass it through and keep the bond as set.
Any objection, State? It's a $100 bond?
Right, he's being held no bond on count one.
Count one was the burglary charge.
Any objection to probable cause?
The petty theft
One,
count.
burglary with assault or battery.
Judges,
Chief, okay, one moment, Your Honor.
Was it a down file?
No, Judge, it's what he was charged with originally. Actually, it's armed burglary.
What bond were you requesting?
Judge, the only thing that I saw this afternoon was the $25 bond on the second-degree misdemeanor that we're just simply asking the court to pass it through, and we'll deal
Well,
with
that's
everything.
not what I'm seeing here. I'm seeing the
What page are we on,
burglary.
Judge?
It's Donald Cooper.
Yeah, you don't have it, because we didn't have the same thing either, we're looking at petty theft.
Oh,
So they had to change the charge on the that now.
Is it that now?
Yeah,
So it's this, it's been found.
That's correct, Judge.
It's just-
well, the judge this morning didn't do anything on the document I have in front of me.
Because we didn't have that, we only had, we're only on the.
So there's another count, and it was proof evident presumption great on that count?
You had the same thing, it was nothing to do with this morning. We had the petty theft earlier, we did, and now the and the armed burglary. They didn't put it together.
Okay, so we don't have to do it again because it's been done?
No, now you have to do the burglary.
Okay,
So,
so the
That
petty
being said-
theft didn't have proof evident or presumption great.
No, that just was added,
Are you saying a judge found that on this?
yes.
so, Your Honor, the judge found proof evident presumption great on the armed burglary. So he's alleged to have stolen a machete from someone's carport. And now the state has filed a burglary with an assault. And I would like a moment to review the probable cause
Sure,
affidavit,
take your
if I
time.
may. Because that actually changes things. And does Your Honor have the PC
I
in this
do.
case?
Do you need to read it?
I have it right here, thank you.
We just didn't get that printout, so I didn't know about it.
Yeah, no, because they didn't give us the, for that.
Judge, I'm going to argue, and I hope the court will agree with me, that there is no assault in this probable cause affidavit. Now, the state may have information that we don't have, that caused them to change this charge, but in this probable cause affidavit, which is the only thing before the court today, there is nothing to indicate that there was an assault, that there was a threat made, a credible threat made to the alleged victim, and that he was put in fear based on that threat. In fact, if you look at the last paragraph of the second page, apparently Mr. Cooper offered to repay the alleged victim for the machete. And so I'm arguing that based on what we're looking at here today, proof is not evident, presumption is not great, that he committed a burglary with an assault.
State? What would you recommend the bond to be?
Judge, I don't know, 2,500 for a burglary of a,
Well, we don't know what the priors are, so we'll ask.
The state would argue that there is proof evident presumption great. Based on the probable cause affidavit, it indicates that the defendant unlawfully entered the carport area of the residence, and once within the carport, he armed himself with a machete and then deprived the victim the right use and benefit of his property by removing it from the carport area. And as defense counsel indicated, there was a threat being made, and the fact that he armed himself with the deadly weapon, that's when he's inside, and the state would argue that there is proof evident presumption great of the offense and ask the court to hold him no bond.
okay, and I'm going to object to the state putting words in my mouth. I never said that he assaulted anyone. This is language that the
No,
arresting officer.
I agree with
Thank you,
your interpretation. What are the priors?
Judge, he has a delivery of methamphetamine, possession of drug paraphernalia. He has a 1999 career criminal felony that involved an assault of a child under 16 years, as well as sexual battery and a lewd act in the presence of a child under 16, and a 98 theft, as well as a 97 Broward.
Okay? And what is the bond that you would like?
Your Honor, if the court is not inclined to find proof evident presumption great, the state would be requesting a $75,000 bond.
And what's the basis for such a high bond?
Based on the allegations of him arming himself with a machete inside of the carport of the residence of the home, as well as his priors, Judge.
Judge, I would argue that arming himself with the machete is just stealing the machete.
Well, according to the probable cause, am I wrong? It didn't even appear that they had interaction until after he was arrested. And that was not a hostile interaction. It was, I'll pay for the,
It's pretty much what I'm reading,
Weapon.
Judge.
I am gonna find probable cause for burglary. I am going to set bond at $7,500.
Thank you, Your Honor.
The state would ask for a pretrial GPS monitor, Judge.
Judge, I don't see
What
any-
I'm gonna do is I will require pretrial with no victim contact, no indirect or direct. He can't go within 500 feet of the victim, no guns, ammunition, or weapons of any kind. No calling, emailing, writing, texting. He can't visit or even drive by the victim.
Thank you, Your Honor.
Is there any, oh, we have Teresa Williams. Okay. Ms. Williams, you've been charged with possession of Xanax, littering on the highway, and failing to use the sidewalk.
So-
Yes, sir.
Judge, Ms. Williams' bond is $1,000, and she is expecting her friend Joe to bond her out. I spoke with Joe earlier, and he indicated that he will probably be doing just that. If the court will consider pretrial release for Ms. Williams, she is a 38-year resident of South Florida. She's been living with her mother for the past 10 years. She's worked in the past as a waitress, also in retail, and but is currently unemployed and unable to bond herself.
Okay, state, any priors?
Judge, the state would be objecting to ROR. The thing does have multiple figures to appear in violations to PPR. There was a case issued in October 11, 2019, which she was arrested on there for 2 different cases. She has another KPS arrest on June 20th, 2019, another KPS arrest, as well as an arrest for pretrial release on 4 different cases with new law offenses on May 3rd, 2019. On February 2019, the defendant was arrested for cases for this case as well. Then dating back to 2017 and twice, as well as in 2018, there are also KPS arrests.
Based on her priors and failure to appear, Judge Cawthon actually found probable cause. I'm gonna just support her decision.
Thank you, Judge. Ms. Williams, I spoke to Joe. He said he will probably bond you out. So good luck to you, ma'am.
Good luck, ma'am. Okay, I think we're done. Anything else before we go? Okay, thank you very much. Good luck, everybody. Happy Valentine's Day.